It's not an isolated case here, this forced labour instance. It's really how manufacturing takes place in a lot of these countries that are very heavily reliant on migrant workforce.
Hi there, and welcome to Voices from the Institute for Human Rights and Business, also known as IHRB. I am Deborah Sago, and in this podcast, you'll hear from people working to make respect for human rights part of everyday business. You just heard from Anna Triponel, the founder of Human Level, a consultancy that helps companies address human rights risks in their supply chains. Anna was talking about the recent legal case involving the company Dyson and a group of migrant workers from Nepal and Bangladesh. People are calling this a landmark case for business and human rights. But why? My colleague Salil Tripathi explores the answer in a conversation with Anna and Oliver Holland, a partner at Leigh, the law firm representing the workers in the Dyson case. Salil's with you now. Salil, can you tell us a bit more about this case?
Sure. So one of the things that businesses have grappled with for a long time is, of course, modern forms of slavery. And one of the manifestations of that is the fact that workers who are migrant workers and who work away from their home in vulnerable situations end up having to pay the recruiters and end up having to work in non-unionized settings or in ways that are, much longer than they ought to work and beyond the normal working hours. So there were a group of Bangladeshi and Nepali workers who took the company Dyson to task. Dyson is a British company, a British Singaporean company, because now they are based in Singapore, and they had facilities in Malaysia in their supply chain. Usually, when people have gone after companies and tried to prosecute them, they tend to be direct owners of the facility, such as the case that took place earlier in Zambia with Vedanta and so on. But here, this is an interesting case that is the supply chain responsibility that became an interesting case. Dyson did not admit any wrongdoing. The case was heard in the English court, and the English court basically ruled that yes, the case can be admitted. And because of that, Dyson decided to settle the case, and it has created a kind of a precedent about the kind of remedies that are available to workers in vulnerable situations. And these are the kind of cases that will test the strength and resilience of the system on one hand, and the way in which the parent company has a relationship with its supplier.
Why did you want to speak to Anna and Oliver in particular?
So Anna wrote a very nice blog the other day in which she looked at takeaways that she thought were important from this case. She writes on business and human rights issues frequently, and Anna has field experience. She has worked with the team of Professor John Ruggie. She has also worked on human rights due diligence for a long time, and she has been observing the situation for a long time. So Anna wrote a post on LinkedIn. A lot of people read it, shared it, and spoke about it. It came to our attention, so I reached out to her to speak about this issue. And Oliver Holland has been a litigator. He has been representing communities and vulnerable people in difficult situations and trying to take the companies to court in order to get remedies for that. So they were absolutely appropriate to talk for this story.
Thank you, Salil. Let's hear their conversation now.
If we take a step back and think about why it's such a landmark case, there are a number of reasons, but the main reason I'll say here today is the fact that we've had an extension in UK courts of what we call negligence principles and how companies can owe a duty of care towards workers. And we've seen over the last 2 decades an extension of that towards workers in subsidiaries. So people hear a lot about the Vedanta case of 2019 or the IHRB case of 2021, where we're thinking through what kind of duty does a parent company owe to workers working in a subsidiary of that parent company. But this is one of the first, although there is another one, the Moran case, but this is one of the first where we are thinking through, what about if we extend that duty of care to workers in the supply chain, in supplier? So that's why it's seen as such a landmark case.
So this lawsuit against Dyson has been over allegations of forced labor in the Malaysian supplier. Dyson, of course, makes household products such as vacuum cleaners and hand dryers and many other industrial and commercial use products around the world. And it's used to be based in Britain, but now it has moved to Singapore. And it is a company that is known for its technical innovations and quite well liked in the British corporate establishment. But suddenly, it is now becoming a very interesting company from the business and human rights jurisdiction issue. But as Anna, you pointed out, this raises some significant questions about corporate liability across borders. The claimants have said that Dyson is liable for exploitative conditions, with the court finding that the case has a real connection to the UK management. Oliver, how important is this case for establishing whether multinational companies can be held accountable for labor abuses deep within the supply chain?
I think in particular, the Court of Appeal judgment from this case is really important. The Court of Appeal found that these claims are at least legally arguable. The court wasn't deciding whether the allegations were true, but it accepted that it had a real prospect for success and that the appropriate place for these claims was the English courts. And I think it goes to a trend we're seeing over the last few years, that the English courts are very much open to these sorts of cases being heard here. Obviously, we have IHRB, we have Vedanta in the Supreme Court. We obviously had cases before that, but what we're seeing, and more recently in the Brazilian case, we're seeing the courts being open, and arguably the English jurisdiction now is probably one of the most hospitable jurisdictions for these sorts of cases. So it's incredibly important in that way.
Now, multinationals have often argued that suppliers and not brands are responsible for labor violation. Now, whether we talk about cases such as what happened in Bangladesh with Rana Plaza, for instance, or earlier with Gap and other companies in Southeast Asia at the so-called sweatshop factories, they've always said it's the brand that should be less responsible for it than the actual supplier. Now, what does this case tell us about where responsibility realistically lies between the brand, the contractor, and even the recruitment agents? Because here we are talking about migrant workers who have been involved. What sort of lessons can we draw by companies about due diligence in the supply chain? Have we broken new ground now?
So if we go back to Vedanta, and what we obviously, as you say, it was what we call parent company liability. So the responsibility of the UK parent company for the actions of its subsidiaries. Now, in Vedanta, the Supreme Court set out 5 criteria, and it wasn't an exhaustive criteria under which a parent company may be liable. But it wasn't limiting it to a parent company subsidiary relationship only. It was very clear that it was outside of that as well. And what you're seeing here in the Dyson case is the implementation of those principles. And you're seeing that in certain situations, particularly where a corporation takes responsibility for certain areas through publishing of mandatory standards, through auditing, through publishing in their corporate materials, what they take responsible for. And when that fails, then therefore there may well be a duty of care. And if they breach that duty of care, then they may end up being liable in the English courts. And that's what this is showing. It's an extension of Vedanta. It's a natural next step. And we're seeing more cases being brought in English courts on a supply chain basis, not just on the parent company liability basis.
Right. Anna, given all your experience, what is your take on this?
So when I'm out on the ground doing human rights impact assessment work, I have worked with suppliers that have forced labor in their factories, that either the workers have come in having paid a fee before, or literally they have, for this job, they've paid the fee. And I said to them, well, why? Why are you resorting to forced labor? And how could you not do it a different way? And they're like, well, we can't. There's such fast turnaround. The buyers are changing their orders at the last minute. The prices here are really tight. We need the workers here day and night to be able to have the spillover of capacity and to be able to meet the production targets within the pricing. So they are telling us, oh, it's on the buyers. Right? Then when we go to the buyers and say, well, what about you? How can you ensure you don't have this forced labor happening in your supply chain? The buyers say to us, well, we'd love to not have it, but we have not found a recruitment agency that can actually do it, even if we are still paying for the workforce, because they'll do a double dipping thing of getting fees from the company and also getting it from the workers. We haven't seen that our peers are really doing it. It's a bit like a lip service to the employer pays principle, but actually are really buyers doing it? Are they factoring in the price of labor? And governments, where are the laws, how they're being enforced? And then you have the government saying, well, we have the brands telling us that if we make things too expensive, they're not going to come in. So there's this thing happening of sort of everyone's passing the buck to each other. But that makes sense because we are actually in a system that is endemic, and it's not an isolated case here, this forced labor instance. It's really how manufacturing takes place in a lot of these countries that are very heavily reliant on migrant workforce. So there are huge profits to be made. The ILO has said it's 236 billion per year is being made from not paying the wages, and that's going into the pockets of these gang masters making the money. So we are set against this huge economic model of forced labor that's making money. So how do we counter that? And so I just think that question is really important, the one that you asked about, where is the responsibility? It lies in all of these players in the supply chain and also the governments that have their own duty.
If you look at it globally, are there similar trends that you see elsewhere?
When I posted this in my newsletter, it was, I must say, the newsletter that got the most traction around the world. So many comments and so many emails I got from people. People really were fascinated by this case. They still are. I think one of the reasons is the way in which Dyson responded to the case. There's the facts and there's what's happened, but it's also the way in which Dyson disputed the facts and then to have sued Channel 4 for reporting. So I think there's a lot of discussion about that as well. But really, it created a whole discussion that I saw about, will it just mean that brands will no longer be doing this in the UK? Will they just be going to other jurisdictions? Because if they don't want the UK courts to have jurisdiction, that won't happen in a way that people are saying, because as Oliver's describing here, there's this trend across jurisdictions of a number of courts. We're seeing it in Canada, we're seeing it in France, we're seeing it in the Netherlands. The courts are saying, yeah, I think it is our responsibility to look more at these cases that are happening in supply chain. So they're finding hooks for those cases. And in parallel, we're having these due diligence laws that are also giving the teeth for that due diligence and enforcing it. So if companies are being advised by their lawyers, the takeaway is don't take that responsibility and don't do due diligence, don't set the policies, don't monitor. Well, you'll then fall foul of the due diligence duties and maybe at the import bans, which have a lot of teeth to them. So I think really the lesson is we're taking a step back. We're seeing this court case within the wave of the court cases that are happening and the regulation. And together it's showing companies, human rights due diligence really is something now that is regulated and legal and expected. Soft law, hard law by the courts.
I'm really glad you talked about the centrality of the debt bonded system. But here's a question I hadn't planned. But since you mentioned the lawsuit against Channel 4, I had a question, if either of you can comment on it, that is this what one might characterize as SLAP, the strategic legal action against public participation, trying to get a prior restraint and preventing the media from reporting something? Or is it, of course, Dyson should not let public criticism be stopped in this kind of a situation. What kind of remedies are there?
I wouldn't want to necessarily comment as to whether it was a slap or not. I think maybe conclusions can be drawn by the fact that they withdrew it, but I wouldn't want to comment directly on that. But I think slaps generally are a real issue. Probably less so in this jurisdiction, although also an issue. But for migrant worker activists, migrant worker lawyers in many Asian jurisdictions, particularly Southeast Asian jurisdictions, the risks to lawyers representing workers and trying to get some public attention on their cases, the risk is really high, and the penalty can be severe, including criminal prosecution, which is really, really tough for them. So I think slaps is a really important issue in this area, which something really needs to be addressed in many jurisdictions.
Salil, I often get called in to companies when they're facing these kinds of issues. And I always see this sort of, I think always, in fact, but it manifests differently. This tug of war between lawyers who are trained, and I get it. I'm a trained corporate lawyer. I've been passed the bar in 3 jurisdictions. I've practiced law, and that's how you're trained, right? It's like I protect the company at all costs, and you're taught these things. Like, well, let's make it drag on. Let's dispute the jurisdiction. Let's use all the tools in our legal toolbox to win. And I get it, but that's just not how the business and human rights world works. And so if Dyson had been able, when they found out about the claims or the allegations, let's say, in 2019 from Andy Hall, which was 2 years before the court case was filed, they could have said, what's happening here? But it's a collective issue, is it not? What about the other brands? Surely other brands have it too. We're not the only ones. What can be done? How do we bring the Malaysian government into this conversation? There's a lot more that could have happened right at the beginning to really prevent all the stuff that's happened since. And so is this a slap? Is it not? We know that Dyson has disputed that it's not. I would say in the business and human rights space, actions like this, lawsuits that have the chilling effect, that ripple way beyond this case, are categorized as slaps in the sense that it has a chilling effect on anybody else who wants to bring these cases. I'm not arguing that Dyson wants to defend its reputation, but that's not how you do it in the business human rights space.
No, absolutely. But since you brought up Malaysia, and since both of you have experience of many jurisdictions, is Malaysia particularly vulnerable to issues such as is it question of poor regulation, poor enforcement, or is it symptomatic of something much larger in the developing world?
Yes and yes. And Malaysia is higher risk, but so are many other countries in that region. I'd say the minute you have this sort of perfect storm of high reliance on foreign labor, employer-tied visas, we know there's been some relaxation in Malaysia, but still, employer-tied visas, recruitment intermediaries that go beyond boundaries, and then gaps either in labor laws compared to international standards or in the enforcement and implementation of those laws. That's a recipe for forced labor, combined with, of course, pressures from buyers coming in on cost and production schedules. So it's not only Malaysia, but yes, it is also Malaysia.
Right, right. Now, this is again a question for both of you, which is about another intermediary which comes into the picture. And you alluded to it when you talked about human rights due diligence. And what I'm talking about are the social audit firms, which are sent to monitor factories. Based on what we know about this case and other similar cases, what does it reveal to us about the limitations of social audits, inadequacies, and failure for the conventional supply chain auditing? We know, for example, from the Chinese case of Xinjiang, where the auditors are not even able to go to the place where they are supposed to be auditing from, and yet they are supposed to write their modern slavery statements and so on. So are audits working? Oliver, what do you think?
I can speak from my opinion. I'm sure Anna is a lot more experienced in this than I am, but from a lawyer's perspective, no. And broadly, no. I mean, there are probably some instances where they do work, but what we see is that audits consistently fail for a number of reasons. Not because they don't take place, but because they're ineffective when they do take place and they don't address the issues at hand. Obviously, in the Dyson case, the High Court, when it made its judgment ordering the defendants to disclose documents, internal documents, early in the proceedings, part of those documents were the audits that took place prior to the allegations brought by the claimants. And those internal documents would have been absolutely key to the case, to establishing liability, understanding what actually went on behind closed doors. And I suppose that goes to the point that auditing should also be transparent, and any audit that does take place, it should be put out into the public domain, so it's possible to understand what is actually happening behind closed doors. I should also add that I think there's another trend potentially in litigation is from supply chain liability to auditor liability. And I think that's the next natural step. And we've actually representing Burmese migrant workers in a case against Tesco and Intertek that's going to a jurisdiction hearing later this year, brought against Intertek as well as the brand, Intertek being the social auditor that audited a factory in Thailand. So I think if auditing isn't working, then there's also potential for legal liability to attach.
And Anna, your thoughts?
Buyers are very drawn to audits because it provides this really lovely sense of comfort. Like, I've got 95% the tick mark and then just 5% corrective action plan. And here's what I need to work on. And I can, close out my non-compliances over the year. Like, it just creates this sense of I can manage this issue. But as we know with forced labor, that just isn't how it can be managed. So I just want to give two examples that I think are really illustrative. So I was working on forced labor in Qatar, and one company I was working with said, okay, all the people who came over from other countries to Qatar, we asked them when they came in, have you paid a fee? We really want to know. And they all said, no, we haven't paid a fee. And then they spent 6 months of sort of getting the comfort levels up, all the, sort of worker voice and extending that to comfort levels, higher. After 6 months, same question, 95% said, yeah, actually, we did. So, and that was an audit too, but like the comfort levels was so much greater, and there was a sense of everything around it worked for that audit in that case in point to work. But that's very, very rare. And what often happens, and this is the second example, as in Thailand, just after the seafood, do you remember the seafood forced labor with Nestle, etc.? I was working on this and I was saying, okay, what's happening? What's happening? Tell me. And they're like, yeah. Our passports are no longer being retained. Anna, we've got the key. You know what? They're taking our ATM credit cards now. It's like, so it's the same.
Yeah.
The point is, all these audits and these systems, they can either find something, but then the actions that they recommend, yeah, we found it. And we did see that some of those audits do find forced labor, but the action is, stop taking the passports away. Yeah, but something else will just replace it. Or they don't find it because people don't feel safe enough to raise it, and they don't trust that when they raise it, they will get keep their job next week. So for sure, the system has to be much more worker-led, what are workers feeling, what can they say, how safe do they feel, and then having some security that when they speak up, they won't be fired and just replaced. And then that the solution that you raise is meaningful. It's like, oh, how do I sit down and tackle this issue? Because I'll just say, forced labor and supply chains, it's not a surprise. We've been tackling this issue for years. And since the Modern Slavery Act we've had passed, it's got worse. Why? Because there's so much money in it and because the economic systems enable it to happen. And so the solution, of course, is not more audits. We know the issue. It's more, what can we do about it? And let's be honest about how we can tackle it.
Wonderful. Thank you. Yeah. I want to return to the issue of Dyson as a precedent. And I want to go back to the question of the supply chain case and focus on the English courts. You both alluded to the fact that the English courts are now playing a more active role in applying international standards. Will we see this as a trend? Because a few years ago, when the Shell case had gone to the US Supreme Court and the Alien Tort Statute was significantly, its scope was narrowed. At the same time, there have been judgments such as the Chiquita case a couple of years ago, the Earth Rights case that took place in the Florida court, which did show that it was possible for litigants to come for a civil liability issue, even in a US court. We have the Shell case in the Netherlands and so on. So are we seeing greater scrutiny, greater awareness and greater willingness on the part of courts to listen to the arguments?
Yeah, I believe that there is definitely a trend towards greater access to courts for litigants in these kind of situations. Certainly in the English courts, we've seen an uptick over the last, I'd say, 10 years. Obviously, at Leigh, we've been doing it for nearly 40 years, but we've certainly had an increase recently and an openness on the courts front in terms of allowing access to the courts for these type of litigants. And obviously with regulations coming in Europe and in European countries individually, we're seeing generally, I think, a greater degree of accountability in the business human rights field. But I think there's still quite a way to go.
Anna, what's your experience? What do you want to add to that?
The fact that this case has now settled has triggered, of course, a big discussion about, well, is that better for the claimants? Is it not? Is it better for other forced labor victims? Is it not? I think on balance, one can say that it's better for justice in the sense that that Court of Appeals case, as you were saying, Oliver, stands, it's strong. And so for any company now that has a global supply chain, that has operations in the UK, they're thinking, oh, okay, that could be applied to me. Because we don't have that decision on the liabilities. The threat is open and is there because we don't actually know where they would have landed. So I think it's, in a sense, it's a little bit more, it's not, the word isn't scary, but, a little bit more on notice, right? Companies a little bit more on notice, and legal departments need to be able to know this is there. But the answer not being, I take away any decision making or my decision, the documents from the UK, more about how can I lean in and have what I need ready for when the time comes, or that I'm proactively disclosing before I get the lawsuit.
Yeah. Keeping the migrant worker in mind again, the most vulnerable part of the chain here, what would meaningful justice look like for him or her? Beyond compensation, what kind of reforms do we need? Legal, corporate, regulatory, to prevent similar abuses? This is almost philosophical, the question, but I'm curious about your thoughts.
I think when it comes to remedy, this is an important point, which is that what I've seen in my work is that often companies equate reimbursement of recruitment fees with remedy for forced labor. Often, I have to remind people, look, I get it. Yeah, of course, it is good, of course, to reimburse recruitment fees. But beyond that, though, there are other harms that have been lived, and sometimes for years, by this migrant worker. And actually, remedy is also preventing that harm from happening in the first place. So remedy is both the backward-looking and the forward-looking. So, for instance, we did the independent report for FIFA on the migrant workers for Qatar, which study I know that you've read, and it came out a couple of years ago. And we argued for FIFA for the migrant workers in Qatar. It's, yes, the reimbursement, all that, but also the hardships that they lived for so many years, having to reimburse, the toll on your emotional well-being of that repayment, being in debt for so long, being the primary breadwinner, earner, and sending the money back, but not having as much to send back, and knowing that your children are going to suffer from that. It takes its toll in such a heavy way. It's hard to quantify that toll, but if you bring in that forward-looking angle of how you can prevent it from happening and working with governments to try and create the enabling environment for it to not happen, the remedy is this, as we call it, the bouquet of remedies. It's all of these different things coming together.
I think also, just to add to that, I think with settlements in particular, obviously, if you go through to a trial and you have a final judgment, then the court can really only order compensation. But and obviously under the common law, there is can be quite wide ranging, and it can include things like Anna suggests, such as the conditions of forced labour and the impact of that on them. But the benefit of settlement, of course, is that you can then be much more creative with what settlement looks like. And I think that is why settlement can sometimes be better. We've had various cases in the past where we've had real sort of restorative justice measures, which have included not just compensation, but many other factors as well that have really benefited people on a much sort of longer term basis. And I think that really means that settlement can be a much more creative tool than just going through and getting a judgment and getting a normal sort of remedy in terms of compensation.
My final question is to you, Anna. You had written some very succinct 8 takeaways from the case. For the benefit of our listeners, can you just go through those? Because it's a wonderful bullet point depiction of what you learned and what people need to learn from the case.
Thanks, Salil. And this really was inspired by my experience working with companies when they're in this tug of war that I mentioned, with the lawyers that are trained a certain way to protect the company, and then often the business and human rights practitioners or sustainability practitioners saying, well, I get that it feels more comfortable to do it like that, but actually for business and human rights, the answer looks different. And I was really trying to equip the business and human rights practitioners to create that conversation before it happens, because I've also worked with companies that have sued and have really regretted it because it's in the heat of the moment and sort of trying to defend reputation. So my key message was, let's prepare for these eventualities before they happen. So number one, UK courts are taking a stronger stance on overseas human rights impacts. Number two, the inequality of arms is central to jurisdiction decisions. We saw in the arguments here that the fact that there was such a vast inequality between Dyson, major global profit-making entity, and these vulnerable workers that had come over for a job was really central to the jurisdiction decision being in the UK. And the latest decision that came out in January, Justice Pepperell was very strong on underscoring the importance of that. Number three, that the duty of care is evolving, like we've just discussed, from subsidiary workers to supply chain workers. And Oliver, you really reminded us that while the elements were there already, this is simply an application of that is novel to the supply chain workers. Number four, that jurisdictional tactics, so disputing where the court case takes place, does carry risk. It might not feel it when you're doing it, but actually in this case, Justice Pepperell in January really took badly to that and said, we have delayed this too much now, Dyson, and we need to now get on with this. Number five, I say, defamation strategies are never a good idea when facing a business and human rights dispute. That suing journalists or NGOs tarnishes your reputation. And of course, the better response is to lean in and engage. Number six, beware of short-sighted legal advice. Sometimes from external lawyers coming in and giving you what you need to be thinking of, but not actually looking at the UNGPs. Number seven, align legal and communications teams with the UN guiding principles. Lawyers, of course, need to understand that there is this soft law that is also shaping hard law, that is shaping expectations of companies in this space and how they respond. I was struck by Dyson's interview when they were interviewed on Channel 4. Their representative didn't talk at all about the UN guiding principles. They talked about CSR. It's a shame. If they had had more understanding internally, that interview could have come up a lot stronger. Number 8, level the playing field. And this is essentially the fact that this is Dyson, but it's not about Dyson. This is about global supply chains and what's happening. So if companies can really own that, say, okay, how can we level the playing field so that across the board we can up the standards? We need to be playing a role with other stakeholders, including governments, to be doing that. Those are my 8 takeaways, Salil.
Thank you. Those are very useful. And Oliver, if you have any final thoughts to add.
No, those are excellent takeaways. I couldn't improve. I should just add, though, I think what we really need to see in the English jurisdiction is some regulation, legislation, and improvement on the CSDDD that's happening in Europe. And that would really go a long way to avoiding some of these really long disputes over jurisdiction and everything else that really delay justice. And that's the really important thing, is these workers who've suffered so much and they need to get justice for what they've suffered.
Thank you so much, and more power to both of you for all the great work you do. It's a pleasure talking to you.
Thank you so much, Salil.
Thank you.
Thank you, Oliver.
Thank you, Anna.
Thanks to Salil, Anna and Oliver for that conversation, which is so important for business to take note of. And thank you for listening to this episode of Voices, which is brought to you from the Institute for Human Rights in Business. Until next time, be sure to share and follow this podcast, that way you will never miss an episode. And if you would like to find out more about the work that we do at IHRB, then head to ihrb.org.